Thank you very much, Bernard, for that introduction, and just like to express my thanks to Bernard and to the community for inviting me to speak to you today about the proposals that are likely to be before us in a few short months. So I'm going to try and provide a sort of a legal analysis of what we're facing into, and I propose to address two issues arising from the government's proposals. First, I want to look at the relationship, the likely relationship that would exist between the Constitution, if it's amended, and any proposed legislation. And then second, sorry, just to explain that in that context, the question there, the background is, would it be possible constitutionally to challenge any legislative proposals brought forward by the government? So that's the subtext there, as it were. The second question that I want to address is to consider what type of abortion regime would likely result from the proposals that are currently being considered. Now, I suppose I have to enter a caveat straight away in relation to both of those questions, and that's to point out that we don't have a text. There is as yet no text of the constitutional amendment, neither is there a draft bill. But there have been indications given as far as the constitutional amendment is concerned that I will work with. And my assumption as far as the legislation is concerned, my assumption is that that will reflect the recommendations of the majority report of the Joint Committee on the 8th Amendment. So that's my assumption for the purposes of my analysis of the legislation. So if I turn to the first question, and just to remind you, the first question then is, what relationship would exist between the amended Constitution and the proposed legislation? And the amendment that apparently will be put before the people will have two parts. It will have what's referred to as an enabling provision, and then it will have a provision deleting the 8th Amendment from the Constitution. And again, just to remind you, the 8th Amendment reads, "The state acknowledges the right to life of the unborn, and with due regard to the equal right to life of the mother, guarantees in its laws to respect and as far as practicable by its laws to defend and vindicate that right." So let me look first of all and briefly at the enabling provision. Now, we don't have a text here, but the government has indicated that the enabling provision will not confer any immunity on legislation dealing with abortion. Okay? And my understanding is that the formula they use would be something like the Oireachtas may legislate for abortion. Now, if they use a formula like that, then the government is correct in saying that that does not provide an immunity from constitutional challenge. If the government wanted to provide an immunity from constitutional challenge, they would use, or the Oireachtas would use, a different formula, something along the lines of, "Nothing in this constitution shall be relied on to invalidate legislation on abortion." That type of formula would preclude any constitutional challenge, but that's not the formula I think that the government are working with. So it would seem that the enabling provision will still allow for the possibility of constitutional challenge to any legislation. Having said that, the fact that the Constitution would be amended explicitly to provide for legislation in respect of abortion, that unquestionably would strengthen the presumption of constitutionality that applies to all legislation. The Oireachtas, when it enacts legislation, is presumed to act in accordance with the Constitution, so anybody challenging legislation has to rebut that presumption. And the presumption is stronger in some areas than in others. It's stronger particularly around sensitive social matters, so I think there would be a strong presumption of constitutionality attaching to any legislation that might emerge if the present proposals are adopted. So that's the enabling provision. Let me turn now to look at the second element in the proposed constitutional amendment. And I'll refer to this as the repeal provision. This is the deletion of that text that I read into the record there a few moments ago, the deletion of the Eighth Amendment. Now, let me summarize my bottom line here, and then I'll spend 10 minutes boring us all to death as I elaborate on that, but you'll have remembered the bottom line. So I think my bottom line is this. I think that there are three possible interpretations of how the Constitution would be affected by a simple deletion of the Eighth Amendment. And it seems to me that under any one of those three interpretations, permissive legislation would be constitutional. But restrictive legislation would be unconstitutional under two of them and would only have a chance of survival under one. Okay, so that's the bottom line. That if the Eighth Amendment is deleted, it will free up the hands of the Oireachtas to provide for a liberal abortion regime. Now, what are these three arguments? Well, the first argument was an argument I put forward, I suppose, about over a year ago now or so. And my argument was this, that if you delete the Eighth Amendment from the Constitution, that does not take us back in time, constitutionally speaking, to 1983, before the Eighth Amendment was introduced. There would be a superficial similarity between the two scenarios. The text in 1983 contained no reference to abortion, and the text post-amendment would again contain no explicit reference to abortion, so you could see there's a similarity. But the way in which we get to those two positions are very different. In 1983, the people didn't speak, they were silent. We didn't know what the people said about the issue of abortion. But in 2018, if the Eighth Amendment is deleted, I would see that as an instruction by the people to the Oireachtas to withdraw constitutional protection from the unborn. The analogy I used when I was writing about this in the Irish Times was that old line about not being able to step into the same river twice. You know, when you put your foot into the river, you disturb the river, and even if you pull out your foot, the river has changed. Similarly, I think the act of deletion would affect the interpretation of the Constitution. Now, that position generated a bit of discussion at the time. The Irish Times more recently has described it as a minority but not fringe position, so I'm not a lunatic. I'm in a minority, but they see it as a credible position. Okay? Now, the significance of that position was that if I was right, then the only constitutional factor that would be in play in relation to the whole question of abortion would be the undoubted constitutional rights of the mother, her right to life, but also her right to privacy, her right to autonomy, her right to bodily integrity. And if they're the only constitutional rights that are at play, and if the unborn have no constitutional rights, then any restrictions on her rights would have to satisfy what we lawyers refer to as a doctrine of proportionality. We would have to show, the legislation would have to show that it was rationally connected to a legitimate object, that it impaired the mother's rights as little as possible, and then be such that the effects of the mother's rights were proportional to the objective. And that's a difficult enough test to satisfy. And suggests to me that if you had restrictive legislation that sought to curtail the availability of abortion, it might fail to pass that test. It might be argued that the restrictions were not proportionate to the objective of preserving fetal life. So my argument, when I was putting forward the argument, the subtext here was to say, look, if we go for a simple deletion, the government may not have the option of restrictive legislation. But of course, the political environment has sort of changed, or my understanding of the political environment has changed since, because it now looks as if the government proposals are going to be fairly liberal. So my argument has been overtaken politically, if not constitutionally. Those who challenged my argument pointed to other jurisdictions where the social interest in fetal life was taken into account in legislation, but my reply to that would be to point out that I'm not aware of any other jurisdiction where an explicit constitutional guarantee of the right to life of the unborn has been withdrawn by decisions of the people or the appropriate constitutional authority, and that would distinguish us from other jurisdictions, say such as the United States or wherever, where the people haven't spoken explicitly on this point. So I stick by my minority non-fringe position. Now, I could be wrong. There are two other possible interpretations. So the next interpretation is the suggestion that, notwithstanding the deletion of the Eighth Amendment, that there would still be constitutional protection for the right to life of the unborn, that other aspects of the Constitution would afford protection, constitutional protection to the right to life of the unborn. The significance of this argument is that if you've got two competing constitutional rights, in this instance, rights of the mother versus the constitutional rights of the unborn, the test that the courts will use for determining whether legislation is constitutional is a very deferential one. Basically, they will uphold legislation unless you can show that the legislation is contrary to reason and fairness. And it's a very deferential test. It's not easy to establish that the Oireachtas has acted unreasonably or unfairly. Okay? So on that analysis, permissive legislation would pass muster fairly easily, but also restrictive legislation would pass muster relatively easily. That if the Oireachtas decided to go for a restrictive abortion regime, and if they were balancing the constitutional rights of the unborn against the constitutional rights of the mother, the courts would generally sort of back off, and unless they had done something that was patently unfair or patently unreasonable, the courts would uphold the legislation. Now, that is, as I say, that's a second interpretation of what would happen post-deletion. I don't agree with it because when I look to see where the Constitution would provide protection for the unborn in the absence of the Eighth Amendment, I can't find a particular provision or a particular argument. Father Harris has already mentioned one possible argument which was rejected by the Supreme Court in 1995. That is the argument that the Eighth Amendment doesn't constitute the right to life. It acknowledges the right to life. By implication, the right to life predated the Constitution, and that therefore the people did not have the lawful authority to withdraw the right to life from the unborn. But that particular argument was rejected by the Supreme Court in 1995 and wouldn't fly in any constitutional challenge to anticipated legislation. There is reference admittedly made to the right to life in Article 40, Section 3, subsection 2, which was part of the original Constitution in 1937. It explicitly refers to the right to life of the citizen. Could the unborn come under that heading? Probably not. The late Mr. Justice Hardiman, in a case called Roach versus Roach, dealing with the constitutional status of IVF embryos, expressed the view that original reference in 1937 referred to born people, and that it didn't apply to the unborn because it would make a nonsense of the Eighth Amendment if the Article 40, Section 3 had always applied to the unborn. Now, there are dicta. What's dicta? These are sort of comments made by judges that are not legally binding, they're persuasive. There are dicta from a number of judges prior to 1983 expressing the view that the Constitution, even before the Eighth Amendment was adopted, that the Constitution protected the right to life of the unborn. But those comments are not binding, and they were made in a different context. They were made in a context where there was no Eighth Amendment. It seems to me that the enactment of the Eighth Amendment has changed the context, and the withdrawal or the deletion of the Eighth Amendment, would not leave open I think for argument, those judicial comments that there's some sort of implied constitutional right to life on the part of the unborn. Finally then, just on this particular point, there's this case which is currently going before the Supreme Court. You would have heard about it this morning on the radio. Mr. Justice Humphreys in the High Court some time back indicated that the new children's rights provision, Article 42A, which was enacted, came into effect I think in 2015, that applies not just to born children but to preborn children. And that has now gone on appeal to the Supreme Court, and there's a discussion this morning. The pro-life campaign are seeking to have the right to make arguments as amicus curiae in this particular appeal. Does that decision of Mr. Justice Humphreys, assuming, if we assume for a moment that it's upheld, does that decision amount to a statement that Article 42A protects the right to life of the unborn? No, it doesn't. Because what Mr. Justice Humphreys was dealing with was the question of deportation of the father of an unborn child. And he was talking about the constitutional rights that a child, born or unborn, would have in respect of its relationship with its parent, its father. He doesn't avert to the right to life. The clear assumption is that, as he's entitled to do, that the unborn had a right to life under Article 8, under the 8th Amendment. Remove that right to life, and any other constitutional rights that the unborn has are entirely contingent. They fall away. In the same way that any of us here, our constitutional rights are dependent on us having a right to life. We all have a right to freedom of expression, freedom of association, freedom of religion, but that all depends on us, first of all, asserting the right to life. And in the absence of the right to life, these other rights are simply contingent, and they won't apply. So I don't see this particular decision. I can understand why the government is anxious to get it out of the way, but I don't see this particular decision as establishing that Article 42A protects the right to life of the unborn. So for all of those reasons, I think the second argument is wrong. But if I'm wrong on that, then the second argument would allow, as I said earlier, the Oireachtas to balance a right to life of the unborn against the rights of the mother, and such legislation, whether it be permissive or restrictive, would get due deference from the courts. The courts would be reluctant to strike it down. Now, the third position is that the mother has constitutional rights, the fetus has no constitutional rights, but that nonetheless society, parliamentarians acting in defence of the common good could decide to restrict the constitutional rights of the mother. Okay, so in this scenario, we're talking about legal protection for fetal life, but it's not legal protection that's based explicitly in the Constitution. It's based on the more general notion that the common good exists and that protecting fetal life is an aspect of the common good. In that situation, in that analysis, we're back to the first position I outlined. We're back to this doctrine of proportionality. There's only one set of constitutional rights in play, those of the mother, and to the extent to which those rights could be restricted in the interest of the common good, you'd have to show that those restrictions complied with this doctrine of proportionality. Okay, and as I mentioned previously when I was dealing with the earlier argument, I think it would be very difficult for restrictive legislation to get through that particular, or get over that particular hurdle. So in conclusion then on this particular point, and I'm coming to the conclusion of my presentation just to reassure you all, in conclusion then on the constitutional point, my bottom line was 3 possible ways of interpreting the Constitution after if the 8th Amendment is deleted. Under any 3, permissive legislation will probably go through, and restrictive legislation would only survive in one of the 3, the intermediate one that I described, which I don't think accurately is inaccurate or a valid argument. So that's, in conclusion then, I think if the 8th Amendment is deleted, the possibility of constitutional challenge to liberal legislation certainly would not be very high. So the second point that I want to consider, and I'll be briefer on this than I was on the constitutional point, the second point that I want to consider is just to ask the question, what type of abortion regime is likely to result if the recommendations of the majority report of the Joint Committee on the Eighth Amendment, if those recommendations are acted on? And just to remind you briefly, what are those recommendations, the main recommendations of the report? The majority report. There are four. The first is that termination of pregnancy should be lawful where the life or health of the woman, the mother, is at risk, that no distinction be drawn between physical and mental health, and that gestational limits for termination of pregnancy should be guided by the best available medical evidence and provided for by, in legislation. Second point, recommendation made by the majority report is that it should be lawful to terminate a pregnancy without gestational limit where the unborn child has a fetal abnormality that is likely to result in death before or shortly after birth. Third recommendation is that the law should not provide for the termination of pregnancy on the ground that the unborn child has a significant fetal abnormality where that abnormality is not likely to result in death before or shortly after birth. And then finally, a recommendation that the law should permit termination of pregnancy with no restriction as to reason, provided it is availed of through a GP-led service delivered in a clinical context and within a gestational limit of 12 weeks. Okay. Now, much of the discussion around these proposals has focused on that last recommendation that permits termination on any ground within the first 12 weeks of the pregnancy. However, I think it's worth noting the proposals also envisage abortion on the grounds of a risk to the physical or mental health of the mother, subject to gestational limits to be specified in legislation. Now, a similar ground is provided for in the UK Abortion Act 1967 as amended, subject to a gestational limit of 24 weeks. And the most recent figures that I've been able to find on abortion rates in England and Wales from 2016 indicate that 97% of all abortions were carried out pursuant to this particular provision. Of all abortions in England and Wales, moreover, 92% were performed under 13 weeks gestation. So it seems to me that the proposals of the majority committee, the majority report, will introduce a provision or a grounds for abortion, which in England and Wales has certainly accounts for the vast majority of terminations. Now, the termination rate in England and Wales, the ratio of terminations to pregnancies is running at slightly over 1 in 5. If you assume that the similar pattern would emerge here, and if we take the figures that are given at present about the number of terminations that occur in the case of Irish mothers, whether they travel to the UK or whether they avail of an abortion pill here, the figures seem to be approximately 4,400 per annum. The birth rate here, the pregnancy rate here in 2016 was 68,300. If you divide that by 5, you get an increase to 13,600. So a trebling of the abortion rate. If the British experience is replicated here, now whether culturally that happens, I'm not in a position to say, but just on the maths, that's what the maths would indicate. As I said, the British allow for termination within the first 24 weeks. It's conceivable if legislation was introduced here that the gestational limit might be tighter, but as I've just pointed out to you, 92% of all abortions in England and Wales were performed within 13 weeks. So even a gestational limit of 13 weeks really mightn't make much of an impact on these figures if the British experience is replicated here. Whether that happens, as I said already, I'm not in a position to say. So that really concludes my presentation, and I'm happy to take any questions that people might have. Thank you.